Let's get started. Welcome to Seven Threats to your estate planner, your family security. We kind of introduce ourselves, but you'll see kind of on the screen there. I'm Jack. You can call me Jack. Howard was my dad. We lost him about 18 months ago, and so I've always gone by Jack. So I'm Jack Wires. The attorney and owner of the law firm. Our other attorney is Sarah Reedy, who just waving her hand. And then our client service coordinator is Erica Saldivar. And that's Erica waving her hand. And Catherine Bush is our funding coordinator. And that's pretty much our team. My wife, Becky, works for us a little bit from time to time. And we'll kind of talk about who does what and where, so that you know, but we're very much a team, and we kind of approach the estate planning process as a team, and we're very much a family too. So with that said, let's go ahead and get started. So I usually like to start just kind of telling a little bit about us and why we do what we do and who our team is and our affiliations. So, you know, the reason I got in this, I was in a 25-year career. I was in the employee benefits business with my father. We sold that business in 2007. And I played golf for about a year, and I had to figure out what I wanted to do when I grew up. So believe it or not, golf got boring for me. So so I decided to go back to law school because it was always something I'd wanted to do. Wasn't necessarily sure what kind of law I wanted to practice. I just knew that in my 25-year career in business, I'd worked with a lot of attorneys. Many of them were frustrating to work with. They talked down to me. They send me very surprising bills from time to time that were a little bit outlandish, and they didn't return my phone calls a lot. So I knew I wanted to be of service to somebody in some way, and I wanted to be somebody that would return calls, sat across the table, just person to person, not kind of one above the other, and that I could do things reasonably priced and people would know what they were going to pay. So the day after I took my law school entrance exam, my mom was diagnosed with Alzheimer's disease. And so it kind of, those two things just kind of came together as I was working through law school, or working my way through law school. She was kind of working her way through the disease process with Alzheimer's. I got more involved in that community, and it just kind of led me. I saw a lot of really, really good family stories, families rallying around their loved ones, and I saw some really terrible family stories. People just, you know, when the family should have been rallying together, they were falling apart, fighting, and all kinds of crazy stuff was going on. So that just kind of led me to the estate planning and elder law piece. I put together a team of people that all have personal stories with Alzheimer's, elder law, kind of estate planning issues, those kind of things. So we're all very kind of passionate about what we do, and it's really where our passion lives, and we're all about family. We're all very much family-oriented people, and we're all about families being together rather than being blown apart, particularly at the most critical times. So you can see some of these pictures up here. The one in the kind of the middle and the top is my dad, my wife Becky, and my daughter Willa, and myself at a Tigers game about 4 years ago. Willa's now 6. She'll probably at some point during this thing come in here and be over my shoulder. The picture at the top right is my mom and I, and that's 2 weeks before she passed. We were at the Breslin Center at a Michigan State basketball game. The bottom right picture is my crew now, and that's about 6 months ago. I've got 20-month-old twins. I'm kind of living my life in reverse. I'm a 60-year-old guy with 20-month-old twins and a 6-year-old daughter. And that picture is pretty much perfect. That's pretty much what our life looks like. The little ones are screaming, and Will is looking totally over it. So, and Becky, you know, as I said, Becky works for us a little bit too. And then on the left here is our whole crew here. So there's myself and Becky, Sarah, Erica, and Catherine at a Alzheimer's fundraiser that we did for the Walk Down to Alzheimer's. We're very big supporters of that for obvious reasons. And very, you know, we did Three Men and a Tenor show 2 years ago. We did the Roaring Twenties murder mystery on the riverboat last September, and we're still trying to figure out if and when we're going to be able to do something this year. So so that's really, you know, why we do what we do. It's just something we're passionate about, we believe in, and we're all about family. I mean, it's family matters to us, and it's kind of our slogan. If you can see this over, but where family matters is our slogan. And we try to really my people ask me what my elevator speech is, and I usually tell people I like helping little old ladies across the street. So, and I get to do that a lot, and kind of metaphorically. So, so that's really kind of what we're about. So let's talk about the team and our affiliation. So. Our affiliation, so these are kind of important because we're a small firm. And so, well, where do we get our expertise? Because people come to us with very unique problems. So we want to add some depth to our organization. And one of the threats that we're going to talk about today is having a team of professionals together to help you build a plan that's going to work for you. And our major affiliation is with a group called Lawyers with Purpose. It's about 350 lawyers nationally. There's about 12 firms in Michigan. I think after New York, we're the largest contingent Michigan is of Lawyers with Purpose firms. And we're really built to do that. We're built to help people address long-term care issues, do asset protection planning, and to build plans that are going to bring the family together as opposed to tearing them apart at the most critical time. So that's a group that we can pull from every day. It's kind of through this crisis. Actually, every day we have a noon call we're going to miss today. That's where we can kind of share ideas and figure out what to do, because there's some pretty challenging issues going on right now. Another group that we're kind of at the second biggest affiliation, I would say, is NAELA, which is the National Academy of Elder Law Attorneys. I told you Will is going to try to come in. Honey, you got to wait. Yes, you can do that. Just go ask Elena to help you, okay?
I don't know where she is.
Up in the bedroom. Sorry, guys. Hopefully that's the last time I knew she'd be here. Is the National Academy of Elder Law Attorneys. And it's a couple thousand attorneys nationally and who focus on elder law issues. We're sharing ideas all the time. If we have, we ask each other questions and share best practices and those types of things. We also belong to an outfit called the National Care Planning Council, and that's a group that it's kind of a multidisciplinary group, they call it. It's all the different people that serve the senior and elder law industry. So it is anywhere from financial advisors, lawyers, nursing homes, assisted living facilities, home care companies, insurance people, people that do placement services like A Place for Mom, reverse mortgage companies, anybody that would provide something in service that might be of value to the elder law industry and to seniors. And at this time, it's really not as well developed as we'd like to see, but the website that they have is pretty cool because there's a menu or listings of people that provide those services, and it has a wealth of information. If you ever have any questions about elder law issues, you can go to that site and find out just about anything you ever want to know about elder law, long-term care issues. So it's we're hoping that will develop over time, but right now it's kind of in its infancy, but it is there's a wealth of information there. We're also members of Probate and Estate Planning Council section of the State Bar and the Elder Law section, and we get these, you got to do these certificate programs. I have my probate estate planning certificate. I'm just about done with my elder law certificate. Sarah's just about finished with her probate and estate planning certificate. She just joined the firm last August. And then we're also very involved with the Walk to End Alzheimer's. So that's, let me make sure my speaker's off over here. That's another group that where we can get a lot of information because we deal with a ton of people that have memory diseases, and we're going to talk about that quite a bit today. So just wanted to let you know that there's some depth and we have resources that we can pull from when we get specific, kind of unique legal problems to deal with. So our agenda today, we're going to review the handouts. We'll do an overview of the 7 threats. We'll identify what you came to learn, review the 7 threats, discover how to avoid them, and close, and then we'll talk about the evaluations, answer questions, so on and so forth. So with that said, let's go ahead and start with the handouts. So hopefully, hopefully you guys got something that looks like this. So you're going to have handouts. There's on one of the pieces are kind of what we call the facts, and there's several pages here, but this is kind of the information we're going to cover today. So who needs estate planning? What are estate planning attorneys? What do they do? Do we need to avoid probate? What's a revocable living trust? What's an irrevocable trust? What's a power of attorney? what are Medicare and Medicaid and how do they kind of fit into the picture? What's Medicaid planning? We'll talk about that a little bit. When we're talking about that, it's specifically the long-term care component of Medicaid planning. Charitable planning, what's a last will and testament, and planning for those with disabilities or special needs. So those are all topics that we're going to touch on today. These are included in your materials just to kind of help you. So a day or two from now, if you're thinking about this, it'll go back, you look through those, it'll hopefully jog your memory. Because one of the things I like to talk to folks about a lot is that, nationally about 35% of the people have done estate planning in some way, shape, or form. But what most people don't understand is that every one of us has an estate plan, because if we don't do anything, the state has a plan for us. So if you've done it, we want to make sure that you're all set. It's going to do what you want it to do. If you haven't done estate planning, we want you to understand what the estate plan is and see if it's going to do what you want to do to see if you're all set. So we just kind of, as we walk through the presentation, we want you to kind of ask yourself that question: am I all set? And if you're not, make a note. That's something we want to talk to you about in a vision meeting, about how we get you there so that you feel like you are all set. The next thing you're going to see is, and I don't know how these come to you. So there's one that starts in the front. It looks like this. It says legal services, estate planning services, advisor agency services, client services, drafting department, firm manager, team leader. So that's what we do. So one of the things we're going to talk to you about today too is that we do really just very few things. We try to do very few things and do them very well. We're big believers, and you're going to find out today that this is a really big area of the law, that you're trying to be a general practitioner as a lawyer in today's environment is a really difficult thing to do, to be an expert on something. And we believe you need to work with specialists just like you would in the medical field. So, and you'll hear stories about why that's important. On the back of that page, you're going to see our team directory, and it kind of tells you who does what at the firm. So that's something that you can refer to. The next piece you're going to see is our estate planning process, which kind of is how we conduct our process. And this is kind of born from the Lawyers of Purpose group and how we do this. You're at step one today. The next step would be the vision meeting, and both of those are at no cost. You just kind of got your time and some of your time invested. But hopefully at the end of that vision meeting, you'll understand if you're all set or not and whether you need to do something. If you know you need to do something, you can decide to do it with us, maybe do it with somebody else. But we don't really engage or contract with you until the end of that meeting. And if we did so, then if you decided to move forward with us, you'd go through a design meeting, a signing meeting, a funding meeting, and then a review to make sure that we've got all your boxes in your wagon, and we'll talk about that in a little bit. So you can see my little radio flyer back here. We also have upcoming workshops, a sheet that talks about when the upcoming workshops are. So if you want to hand those out to loved ones, we're going to continue doing these virtually, at least for the foreseeable future. I would imagine the next one, even if the governor does decide to lift the order, we'll probably do that virtually also on April 17th. So if you have somebody else who wants to come, or if you want to come back yourself, we've had people come up to 3 times because they say they learn something new every time they come. Please feel free to come back or bring somebody along. We'd love to have you. Then the last thing is the note sheet. And again, as I said, if you feel like you're not all set, or if I say something, it's like, boy, I really want to explore doing that, make a note of it so that we can talk about it either after this today or at your vision meeting. I think that's really important. I learned it when I got to law school real quick that I was a terrible note taker. And it's that, particularly when you go to educational sessions like this one, it's important to take notes so that you don't forget what you learned, because I used to do that a lot. So that's our handouts for the day. And now let's talk, we'll go to our overview of the 7 threats. So here are our 7 threats. And, a couple things that I like to preface this with is I'm going to spend some time and kind of invite you to come to our office a little bit today and kind of understand what we see. So we're going to try to tell you this stuff in stories more so than legalese. Because I think it's a little bit easier to relate to that way. So, with that said, people say, well, why 7 threats? And so you're going to see there's about 12 to 15 questions that we hear almost all the time from people. And They're pretty specific questions, but what we really try to do is kind of go sit on the other side of our table and say, well, if somebody's coming in, what are the things that are really important to them as clients, not necessarily what's important for us for them to know, but what's more important from the client side of the table. What are the threats? You know, what can go wrong? And how do we find the opportunities there? How do we corral those things and get things going in the direction we want them to go in? That's how we kind of distilled this down to 7. So those 7 things are losing control and access to your assets. So, and typically when I'm in the classroom and I say, how many people want to continue to have control and access to their assets? Everybody raises their hand. So, and we're going to talk a little bit about how that actually happens when you can lose it. And it happens when you least expect it. So we want to make sure that that doesn't happen to you. Not knowing the law. Most people know about 80% of the laws that relates to estate planning and elder law. You know, we kind of feel like it's the 20% that you don't know that is the stuff that you really need to know. You know, most people understand what a will is, but we're going to talk about that a little bit more. But they also don't understand necessarily how it operates. So we get a lot of calls that people say, I need a will. And then when we sit down and explain to them how a will operates, they're like, oh my gosh, they didn't do it. Maybe I don't need one at all. That wasn't at all what I thought it was. So we talk about these and we call them the coffee shop and the barber shop rules. You know, that's where everybody gets their law degree. They go to the coffee shop or the bar or wherever and sit around, they hear horror stories from other people and they learn things about the law. They go to the barber shop or the beauty shop and they hear people talking about what happened to somebody's uncle's cousin in a horror story. And as they come to us and they'll tell us, I need to do this. And it's like, why? And it's because I heard it at the beauty shop. And so we think it's important that you really understand the stuff that you don't know that you need to know. So we'll try to go through that today. Not knowing who your predators are, and the threats to, you know, the actual threats, what we call predators and creditors, we'll talk about. And sometimes people are very surprised about who those people are. The next thing is when your health fails, and we never plan on our health failing. And you know, I use my 2 uncles as an example here. I had my mom's brother who was going to flew to Florida, a healthy guy, flew to Florida for his 40th year class reunion, got off the plane, rented a car, driving the car to meet his buddies. The lady ran a red light, T-boned him and killed him. You know, he never expected that. So you just don't know when it's going to happen. My other uncle was 88, living in Florida at the Villages. His sweetheart died in December. And he called me, I was on the phone with him in March, and he said, I finally got me a golf cart. I'm going to go find me a sweetie. 3 days later, we get a call. He was riding in his golf cart. So, I mean, this must happen a lot in Florida. Somebody ran a red light in a pickup truck. The lady in a pickup truck hit his golf cart. He flew 80 feet, and it didn't kill him. But he lived another 9 months in the nursing home. You know, trying to pull his estate together because he just hadn't done the planning. He never expected that too. He is a pretty tough guy. He probably lived a lot longer than he should have. They told us we were going to lose him several times, but you just never know when it's going to happen. And, you know, we want to have a plan for it. And that kind of leads to the next threat is failing to plan when you can, because it was very difficult for my uncle, who was kind of in and out of consciousness at 88, to adjust and make adjustments to his plan. And he ended up with a daughter and a stepdaughter who ended up pretty much at war with each other as a result of that, him not having done some planning when he could. And my uncle, who got killed in the car wreck, didn't plan when he could. And, you know, it took a long time to kind of sort things through and get them where they were supposed to go. And I guess what we say there is you just have a ton of more options when you if you plan when you can, as opposed to when you can't. So we'll talk about that. Not working with qualified professionals, and how would you know anyway? You know, I always challenge people, say I could be just feeding you a line today. Hopefully by the time we get done with this, you'll understand that I know a little bit about what I'm talking about. You know, there's also some other professionals, and we want to talk to you a little bit about how you might know that you're working with somebody that's qualified and is going to do the things that they want to do. And that's one of the reasons we showed you our affiliations earlier, and we'll talk about that a little bit later at the end and fairly briefly. And then not knowing the costs and what the real costs are. So, because oftentimes, you know, it's you spend a little bit of money now to save a little bit of money or hassle later. And, typically, as I told you, when I went to law school, I wanted people to understand and not get surprise bills. So one of the things that we try to do to the extent that we can is to package price the plans that we put together for people, and then give people an option. So you get kind of a lower cost option, a mid-range option, and a higher range. And it just depends on the person and the situation. People always say, well, I don't have enough money to have a trust. And it's really very situational and based on what your goals are. Some of that is, do you want to pay me now? Do you want to pay me later? So we'll talk about those things too. So with all that said, let's go ahead and kind of move into the presentation. So the first threat, losing control or access to your stuff or your estate. And so, the first thing I say is, what people to understand is, what is your estate? Okay. And well, let me do this first too. So I think one of the questions I get a lot from people, what's the difference between estate planning and elder law? So estate planning is what happens to your stuff when you die. Elder law is what happens to you and your stuff before you die. So the world used to kind of seem like back in the day, the world people lived and then they died. And now we've got people live and then they've got this kind of la land that they're in for a while before they die, and where they can maybe not control their stuff. They're not really able to control their stuff, and they need to be cared for. So that's why this elder law field has kind of grown. And so that's the what happens to you and your stuff if you get sick, but you don't pass, or until you pass. So, when we talk about an estate, really we're talking about your stuff, not you. And your stuff would be, your house, your car, life insurance, the stuff in your house, your bank accounts, any investment assets, retirement plans, all those sorts of things. So that's really what your estate is. And it's very general. It doesn't mean that your probate estate is one thing, or trust estate, beneficiary designation. We're going to talk about all those things and how those things are owned really play into how this all works. But estate planning really comes down to three things: who's in control of your stuff, who gets the benefit from your stuff, and when. So those are kind of the questions that we're always asking: who's in control now, who gets the benefit, and when. So when you're alive and well, hopefully you're in control. So when I first started doing these workshops, I would tell people, it's like, well, I know what the right answer to that, and that is my wife's in control. I'm just trying to do the happy wife, happy life thing. But now I'm starting to learn that my wife, neither one, it's not my wife or me, it's these little rascals running around my house who are in control. But for all intents and purposes, if you're alive and well, you're in control, and you get to decide who gets the benefit from your stuff and when. If you become disabled, you have an accident, you have an illness, and you can't speak for yourself, now who's in control of you or your stuff? Who gets the benefit and who shouldn't? Who decides whether it's the state, you or somebody else? Because we're going to talk about this in a minute. Somebody has to be able to make decisions for you. The state has a vested interest, society has a vested interest of, if you no longer have control to make decisions for yourself related to your finances, legal issues, and your care, custody, medical, and mental health treatment, the state's going to get somebody to do that for you. Or your family's going to make those decisions for you, or you can make them yourself. And I would argue that you should try to make those decisions for yourself if you can. We're going to talk about that a lot. And when you pass, who's in control and who gets the benefit. So that's really kind of how estate planning works. So let me do this. So let's talk about these a couple different things. So let's talk about this kind of alive, when you're alive but you're not well. So if you became disabled and couldn't make decisions for yourself anymore, as I said, the state has a couple different legal proceedings that can go on, and some of you may have heard of these. There's a guardianship, which covers you would go to the court if you can't make decisions related to your your care, custody, medical, and mental health treatment. The state has a proceeding called a guardianship, and there's a statute that dictates that proceeding, where they would appoint somebody to make those decisions for you. So it's a statutory thing. There's statutory priorities, but the judge makes the call. The judge decides what the guardian can and can't do, and the guardian has to report back to the judge. And it costs money. to go to institute a guardianship proceeding, you got to go to the court with $175. If one of your family members was going to take over guardianship for you, they need $12 for letters of authority. They have to pay a roughly $50 to $100 investigation fee. They go and investigate to see if you need a guardian and who's the right person to do it. And then you go to court and the judge will appoint a guardian. If it's contested, those get kind of ugly. If we have different people vying for guardianship, then those things can get pretty ugly. We've had contested guardianships where people have paid us up to $7,500 to represent them. So you have that piece for your care, custody, medical, and mental health treatment. For your financial and legal piece, we have in Michigan what we call a conservatorship. So, and you do the same thing. You go file a stack of papers with your $175, your $12. They do an investigation to see what rights you have, so on and so forth. The judge appoints the conservator, and then the conservator has to account to the judge and report back to the judge all the time as to what they're doing. If they want to sell your house, they've got to get permission from the judge. And the statutes and the judge make the rules. So they make the appointment, they make the rules. So it's not you. It's not your decision. So, and then other times it can be other people. So one of the things that we'll see happen a lot in either one of those proceedings is we'll have three family members, like three kids from, somebody has three kids and all three kids are in there asking to be the guardian, or two kids. And oftentimes what the judge will say, I'm not going to decide between the kids. I'm going to give it to an independent third party. So now you've got an independent third party who's running the show for you. So it really takes it out of your control. What we do have that would replace that, so the decision that you can make yourself is that you can have what we call for the care, custody, medical, and mental health treatment. You can have what we call a patient advocate designation, and some people call it a healthcare power of attorney or medical power of attorney, where you name somebody as your agent, and the court will honor those designations. So mine says I, Jack Wires, grant Becky Wires the legal authority to make decisions related to my care, custody, medical, and mental health treatment if I can't, if I'm not able to do that, whether temporarily or permanently. And then I make the rules inside that power of attorney. So it's very descriptive. And the same with, on the other side, for my what we call a durable power of attorney for financial and legal matters, I appoint Becky to stand in my shoes and to act for me in any financial and legal matters. And we'll talk about both of those documents. So you can make those decisions. And typically, if you've got the most what we call instructive ones, it would cost you less than it would cost for a family member to go down to court and institute the legal proceedings. So it's kind of a no-brainer. So we recommend to everybody that you should take control. You name the person who should be in control. You name the rules that they play. You make the rules they play by. You give them instructions. And what we find is that, people fight. They just do. So I guess the best, let's talk and tell you some stories about these. So with a patient advocate designation, we call that the God proxy, because that's the person that gets to decide whether you live or die if you're in one of these life-threatening situations. And oftentimes what we see is people will name their oldest kid, they'll just kind of randomly name their agent. And most people want to have, if they get into that end of life situation where there's no hope for recovery, they want the plug pulled. Well, if you've got somebody that doesn't have a lot of, that you haven't necessarily had the conversation with, nor do they have maybe the guts, or do they believe the way you do, they may not be willing to pull the plug. So we think you should spend some time considering who would be the best agent. Sometimes if you got three kids, it's better to name somebody who's not a family member, so that you take the decision out of, instead of pitting the kids against each other, that you take the decision into a more independent party and allow them to make that decision for you. And then we think you should have real explicit instructions, because we find, we've had it's been as ridiculous as this, where I've had a daughter come into town, and we actually appointed an independent patient advocate who came into town and said, I don't think my dad's bed is at the right angle. I think it should be at about 40 degrees instead of 48. And you wouldn't believe how people fight over those kind of things. So they just tend to fight like crazy over those things. So we think it's important that, first of all, you name the right advocate, and secondly, that you put real explicit instructions how you want to be cared for in those situations, so that when it happens, you know you're going to get the kind of care you want, and it's going to be according to your rules. And the person that's doing it for you is going to have the rule book to hold up and say, this is what Jack wanted. I'm just doing what he wanted. So that then that prevents the families from fighting so much and the second guessing from going on, and allows the person to do what you wanted to do. So in this, when you see kind of a stock power of attorney, it doesn't typically have as a specific instructions. We think you should have very kind of advanced instructions, and that's what we include in what we call our enhanced patient advocate designation. One of the other things that we include in our document is what we call the second crack at the apple. And so if some of you may have heard of Terry Schiavo or Karen Ann Quinlan, people that ended up on life support for extended periods of time because the family was fighting over whether they should pull the plug or not. And you know what I always tell folks is that the family can't decide, there's no specific direction. If you go to the judge, you're not going to get the plug pulled, because judges get elected and they're not going to kill anybody. I mean, it's just the way it is. They're just not gonna pull the plug on you. So people end up on these extended life support situations. So I'll tell you the story with my mom. So my mom, the picture you saw of my mom earlier was 2 weeks before she passed. And one of the things that we know about people that have memory disease is that they really, and studies have shown, is that they really like to do the things that they like to do before they got ill. So what we knew mom liked to do is she liked to go to Michigan State football games. She liked to go to Michigan State basketball games. She liked to go to Tiger games, and she liked to go hang out at the Michigan Athletic Club. So we made sure that we built her life around doing those things. And so we had a routine that we would follow going to the Michigan State basketball games. And that picture you saw that night we were at the Breslin was kind of the interesting thing with that is it's like the last thing my mom could remember kind of from beginning to end was the Michigan State fight song. And she sang it from beginning to end that night. So, you know, it was pretty cool. She didn't recognize my sister at that point. So, because my sister wasn't really involved on a day-to-day basis. She lives a little bit away from here and would only see my mom like once every 2 weeks. So 10 days after that, we had our routine that we would do. And if it was the night game, we'd go to Mitchell's for dinner. And then we'd go over to the game. So sometimes I could meet them depending on what I had going on. Sometimes I just I'd meet them for dinner. Other times I'd meet them after dinner and we'd go. So as I didn't meet them that night. As I was pulling up to Mitchell's, the ambulance cut me off. And it was, they brought my mom out in the stretcher and she'd had a massive brain bleed. Now that might've been a bit of a blessing based on where she had kind of, her quality of life had disintegrated to at that point. But she had a massive brain bleed. So my dad hopped in the ambulance with her. I got in my car, got behind her, followed him, called my sister, had her meet us. She lives down in Heartland. Had her meet us at Sparrow, and we're all standing in the ER at Sparrow. And this guy who could have been the Wizard of Oz came out from behind a curtain and said, "Mr. Wires, I got a question for you." He said, "Well, what's that?" He says, he goes, "The only way that we can keep your wife alive is if we put her on life support. Do you want to do that?" And my sister's a nurse. So my sister was over my dad's left shoulder. He looks at my sister and she says, "Dad, don't look at me. I'm not making the call." And then my dad looked at me, and I was still in law school at the time. And we're just finishing up. And I said, "Dad, I don't want to make the call either." I said, "I think you need to make this call, but you need to ask the doc what happens if you tell him to put the plug in." And so the doc says, "Well, Mr. Wires, if you tell me to put the plug in, legally you lose the right to pull the plug. We've got to agree with you at the hospital, pull the plug, or you got to get a judge to agree." So, now he had to make a decision right then. So he told him to put the plug in. Fortunately, the social workers at Sparrow agreed with us, and nobody, worked with us. And 3 days later, we decided to take her off life support, took her home, and she passed away peacefully. But there was a situation there that we were in, and even though we knew mom was sick, it was pretty emotionally stressful to have to make a decision right then. The second piece was we wanted a second opinion because we had no idea who the Wizard of Oz was. So we wanted to adjust emotionally. We wanted a second opinion. We wanted to talk to a doctor we knew about what was going on. And my nieces, because my mom's sister had passed recently, my uncle got T-boned in Florida and had passed recently, and my nieces in California said, if Auntie Kay is going to pass, we want to be there with her. So we wanted some time to be able to get the family around. So what we build into this second crack of the apple, we build is kind of a user-defined term, is that you can say, I want 3 days to delay the decision that my advocate has to make about pulling the plug in or putting it out. So they can make it before that, but it buys 72 hours or 5 days, 7 days to allow them to adjust emotionally, talk to other physicians, and to get family around. So, and we were fortunate. We got mom home. She made it through the night. My cousins made it in from California, and they actually held her hand before she passed, and the family was all there. So it all worked out well. But the laws doesn't necessarily set you up for it to work out well. So we build that into our documents. So we think that's a real important piece. And then the other things we do is some kind of unique things with uh, uh, organ donation and things of that nature. So those are all things that you can put in the document. And then really how you want to be treated when you're in those last moments of life. So we think that's really important, and we've seen them work for people. And we've seen ones that didn't work when families started fighting about what was going on, because that's what, people, they tend to fight a lot about that kind of care at end of life and what should or shouldn't be done. So we have that piece. And then the other thing that we have, which is kind of this new la land thing, is what happens if you're in a long-term care situation. The guy that runs Lawyers with Purpose is an Italian New Yorker, so he's pretty gregarious. And so he always says here, what if you're singing and dancing, but you think you're George Washington, but you're in this long-term care situation? So, and as I said before, studies show that people like the things that they liked before. So one of the other things that we like to put together for people are what we call a personal care plan. And it basically starts by saying, I, Jack Wires, if I becomes ill and I'm, going to be in a long-term care situation, I want to stay at home as long as possible. And then if I have to be moved, I want to be moved to the least restrictive environment. I want to stay engaged mentally, physically, socially, as long as I possibly can. And only put me in the nursing home when you absolutely have to. But while I'm going through this, I want you to know how I want to be cared for. So do I want to be bathed and groomed daily? How often do I want my hair cut? I want to visit family. I want to visit them under these conditions, whether am I burdensome? Am I going to be able to add to the situation? Am I presentable? All those kind of things. Here's the special occasions I want to be involved in. These are the activities. Put me on the boat and take me out fishing as long as you can. Take me to the golf course. I had a guy literally used to take me to the bar. He's got his bar he likes to go to. He's like, go sit me at the bar with my buddies as long as I can. Now, once you get to the nursing home, obviously some of these things you can't do, but all the way through the continuum of care, if you have people that are caring for you, they know what you like and what you don't like. So it's hobbies, music, magazines, books, any of those kind of things that you like to do on a daily basis, how you like your coffee, the food you like. Mine says, please do not ever feed me liver or shellfish. I hate liver. My grandpa used to force me to eat it when I was a kid, and I'm allergic to shellfish. So we can put all those things in there. Religious affiliations, whether you want to attend religious ceremonies, be attended to by clergy, all those kind of things, so that we have what your day-to-day life looks like, so that we can hand that off an instruction manual to your caregiver. And when we do that for caregivers, they love it, because now they know how to care for somebody that can't express how they want to be cared for. So that's what we call a personal care plan, and we include that. So that kind of deals with the you piece of elder law. When you're alive, when you're alive, but you're not necessarily well, how are you going to be cared for? So we want you to take, we think it's important that you create that instruction manual, because it prevents family fights, and hopefully it guarantees you're going to be cared for the way you want to be cared for the most we can, and everybody can sleep at night a little better, knowing that the chances of fights, and people arguing about how this is going to happen, are minimized. And that's what we ask people. So kind of going to the financial side, we ask people, well, what do people fight about? So it's like, what do kids fight about? We know kids fight. And oftentimes they fight about money, but, mom and dad's money, but oftentimes it's about how and when, how mom and dad are cared for. So, what mom and dad wanted, we see that just as much as the money piece. But moving to the money piece, we have this durable power of attorney for financial and legal matters. And, I guess the best way to describe this, if I gave you a blank check, what could you take from me? So, and if Erica were unmuted, she would say, you could take everything. And the answer to that question is no, you can only take what's in that bank account, right? So, but if I gave you a super blank check that basically covered all my assets, what could you take from me? then you can take everything. Well, a power of attorney is essentially a super blank check. So, the ones that people used to write back in the day would just say, I, Jack Wires, grant Becky Wires to stand in my shoes legally and financially. She can do whatever she wants. Well, we now hear a lot about elder financial abuse, and the document that people were using to steal money from the elderly were these durable powers of attorney. And so the state kind of cracked down on it in 2012, and they added some new executory requirements. The important thing is that we need two independent witnesses, and we should be notarized, things like that. But the other thing is that the person who you name is the person that who's they now have to sign an acceptance that they're acting as a fiduciary, and if they don't do what's in your best interest and according to your wishes as you understand them, they're subject to civil and criminal penalties. So they can actually be thrown in jail now if they don't do the right thing, so to speak. So what we see though is what we typically see when we see these documents is that they're a semi super blank check, because the state also added some things that said if you want somebody to be able to make gifts on your behalf, because this is how people stole, create joint bank accounts and create trust, then that has to be specifically enumerated in the document. So when you see, and the best way I'll describe this, because I've seen 2 of them this month that caused problems, is we'd get them from UAW Legal Services, and they create what we call the state's stock power of attorney. So it includes all the powers, but it excludes the power to gift, create joint bank accounts, and to create trust. So, and people say, well, that doesn't seem like such a bad idea. Well, we're going to talk about long-term care planning and asset protection planning down the road. If you can't do those 3 things, typically you can't do this kind of Medicaid planning that we're going to talk to you about later. And so we have it's kind of in between a blank check and a super blank check. And we think you should have all those powers in there. So we think you should have a super blank check, but you should also have explicit instructions about how you want your money used, so that if they're using these powers, that we've got some instructions, and then they've signed this acceptance that says they're going to follow they're going to do according to our best wishes and our wishes as they understand them. We've expressed those wishes. So now we've got something to hold the whole thing together. And oh, by the way, we integrate that with your personal care plan and your patient advocate designation. So if you need care, we're directing the money to the right place. So we have this kind of integrated instruction manual that deals with you and your stuff together. So, and so as we say, so typically what we see, this would be the typical story we see. So we've got mom and dad live in East Lansing. They've got a kid that lives in East Lansing and a kid that lives on the West Coast. So who do you think they name as power of attorney? Well, they name each other first, and then the next person they name is the kid in town, right? And it's just kind of what happens. We see it all the time. It doesn't matter if the kid in town has been bankrupt 3 times and the kid on the West Coast is in the financial services industry. They just name the kid in town because they think that's kind of an honoring thing to do, or that's the closest person and they can conduct my business. Well, obviously we can do most of our business electronically now. So that's not necessarily the case. So we think there should be some thought put into why who you pick as your agent. The second thing is, so what would typically happen is that dad dies, mom decides it's a good day to have a stroke, and in comes the kid in town to my office with this thing. He says, I got this power of attorney. What do I do with it, Mr. Wires? I say, well, what does your mom want? Because we're supposed to do what's in her best interest and according to her wishes. And he says, well, I think she should she wants this. So we start doing this, and then a couple of weeks later, we get a call from the kid on the West Coast and says, what are you guys doing? And we said, well, we're doing this. And the kid on the West Coast says, I don't think so. I talked to mom 2 years ago on a Tuesday night about 8:30, and I think she wants that. And then they start fighting between this and that and this and that. And then about 3 weeks later, I get a call from the attorney on the West Coast saying, we don't think you're doing the right thing here, and we think we want to maybe take this to the courthouse and see what the right way to do it is. So we think it's important that you put those directions in there. The other 3, and I'll do this briefly because we're going to come back to it. And we also think it's important that you include what they call those enumerated powers. And a lot of attorneys will put that in anyhow, they just don't include the instructions. So we either see one that's too limiting, we see one we call the super blank check, but they don't have these instructions attached to them. And the super blank check, the reason a lot of attorneys will put them in there, they just add them, is they do it as a CYA move. Because if I don't include those, so this would be an example. So if I have an estate that's $500,000, 6 years from now, I have to go into the nursing home and I have one of these attorneys that doesn't include these enumerated powers that Sarah created for me. And my family goes to another attorney who says, you know, that $500,000, if those enumerated powers were in there, I could have saved 300,000 of it for the rest of the family. Who do you think gets sued for the 300 grand? Sarah, because she created the document. So a lot of attorneys will just add it. It's just like, let's just put it in there because that covers our butt. And so we think if you're going to add those enumerated powers, they're pretty broad powers and people steal with them, that you have to have instructions attached to them too. So again, as you can understand, we're really big on providing instructions because we think, first of all, it's going to get done what you want to get done. But secondly, it's going to give the person acting on your behalf something to hold up to everybody else. That's going to stop the fights and say, I know this is what mom wanted. I know this is what dad wanted. So we're big on those instructions and creating those kind of documents. So we think everybody should have a patient advocate designation that's complete with instructions. We're really big on personal care plans that document how you want to be cared for in a long-term care situation. And we're really big on having a super blank check with instructions as your durable power of attorney for finance. And in both cases, you want to, in all cases, you want to appoint the right agent, the person that's going to carry out your wishes and has the chutzpah to stand up to the other people. And that should be well thought out too. So that's kind of what happens to you and your stuff in that elder law piece. So let's talk about the next piece, which is what happens when you die. Now who's in control or who benefits? So, and typically what I ask people here, so that we're going to our second threat, which is, so this is kind of the tail end of the first one, do you need a will or a trust? And typically when I ask people and they're around the room and some people say, well, I need a will. Some people say I need a trust, and most people say you need both. The answer to that question is that, you know, the law school or lawyer answer is it depends. Because if you don't do it right, neither one of them work. And it's just usually at this point in the show, it's just like, yeah, neither one of them work. And so thank you very much. But let's talk about why they don't, because I think that's important. So that kind of leads us to threat number 2, is not knowing the law. Because if you don't know the law, you can't understand, because you can have the best will and trust in the world, but they may not be doing at all what you want them to do. So let's talk about how you get them and how you get them to do what you want to do and how they operate. So there's some things that we need to know. So you need to understand types of legal ownership. You need to understand what a will does, what probate is, what a trust is and how it works, how legal ownership trumps your estate plan, whether you have a will, a trust, both, or neither. So we're going to talk about those. And that's why I said either. It just depends on how you've structured things. So let's talk about types of legal ownership. So you can have these various types of ownership. You can have, and I'll use me for example. You have a joint account. So if I have an account that's joint with rights of survivorship between myself and my wife, if I pass away, it goes to my wife. So let's just say I have an IRA or a 401k, and I've designated that to my son or my daughter Willa. And those those are what we call beneficiary designated accounts. So you have IRAs, 401ks, life insurance policies, annuities, those kind of things that you have put a beneficiary designation on. When you die, it goes to whoever you've designated. Then we also have payable on death and transfer on death accounts. You can see those in brokerage accounts at banks, those kind of things. And basically it's the same sort of thing. This is that by operation, what we can say is by operation of law, when you pass, it's going to go to whoever you've designated them to be either payable or transferable to. Or an trust for account you see rarely anymore, but you see those sometimes at banks. And then you can just own stuff in your name alone. So let's go through this kind of situation. So I have a joint bank account with Becky and I have a 401k that's designated to go to my daughter Willa. I've got a payable on death account that goes to my daughter Presley. I have a transfer on death that goes to my son Paxton. And I have a bank account, $50,000 in my name alone. So my will says everything goes to Becky, right? So if I die and I've named all these other beneficiary designations, does everything go to Becky? So if you kind of go through that, Becky gets the joint account. she gets she doesn't get the 401k, that goes to Willa. The payable on death goes to Presley. The transfer on death goes to Paxton. And where does the bank account in my name alone go? That goes to my estate. So we'll talk about that. So then it would go to probate, and by terms of my will, it would go to Becky. So now we got the joint account and the bank account to Becky, but all the rest of the accounts didn't. So my will didn't really do what I intended it to do, did it? So maybe that didn't work out so well. So let's go back. I want to go back to kind of losing control and access, because to talk about how this happens to people. So I had a pretty good friend of mine who works at a local nursing home. Her husband was up north fishing by himself. He had a massive stroke. Fortunately, they got him. They found him. He's actually doing pretty well now. But for about 4 months, he couldn't talk. She called me up one day and she said, Jack, I should know better. We didn't do powers of attorney. I said, yeah, what's the problem? She goes, I need some of the money from my husband's 401k to pay the bills. And I said, you don't have power of attorney. You can't get it. So you have to go to you'll have to go to the court and get a conservatorship in order to get access to those funds and control of them. Now, if she'd have had a power of attorney, she'd have had access to all of these accounts. But as it stood, she had access to the joint account. She had no access to the beneficiary designated stuff. She had no access to the payable on death, no access to the transfer on death, or no access to anything in my name alone. So that's how you can lose access. So we want to make sure we kind of go through your stuff with you, your plan with you, or your situation with you is that we have a continuum of control if something were to happen to you, and that it's the right people. So the example that I try to use here, so you can see how that can screw up a will, but let's just say everything goes to Becky. So it's joint to Becky, the 401k goes to Becky, the POD goes to Becky, the TOD goes to Becky, and I still got this account in my name alone, but my will says it goes to Becky. So, and I told you, I said, I want you to kind of come back and hear some of the stories that we hear from our office. So if I die, everything goes to Becky. Did the plan work? So, and Becky may think it did. She got all the money, right? But let's change the situation. So let's say that Becky and I were in a car. Becky was driving and we hit another car. And not only did it kill me when we hit the other car, but it killed the driver of the other car. And Becky was found to be negligent. So all the money goes to Becky, right? And then the other family files a lawsuit against Becky. Who do you think ends up with the money? The other family, right? So did the plan work out the way we wanted it to? Probably not. And how do you think Becky and my kids feel about that now? Probably not so good, right? So let's take another situation. So let's say we didn't hit another car at all. We hit a tree and it killed me. So, but it also disabled Becky, and Becky has to spend the rest of her life in a nursing home. Who do you think gets all the money, Becky or the nursing home? The nursing home does. So it's all going to go to the nursing home before it goes to Becky, and then we're back in that situation. So that plan didn't work out so well, did it? So then let's take another situation. So let's just say we're in a car wreck at all, and I just died. So everything goes to Becky, but Becky is really distraught because she's never lost a husband before. And Becky and I have this thing that kind of goes on right now is that she grew up with a swimming pool in her backyard. And I think swimming pools in Michigan are kind of a ridiculous thing because you get to use them for 2 years. So we kind of go back and forth on this thing. But Becky just says, hey, I got some money. I'm going to put a pool in the backyard, right? So she's at home. She's grieving. She's sad. She's alone. And they come to install the pool. They get the pool installed, and the pool maintenance for the pool boy shows up a couple weeks later. His name's Biff, the pool boy, and he looks really good in a Speedo. And Becky really likes to see Biff in a Speedo. So Becky's sitting in the house. She's forlorn. She's looking out the window. Biff's out cleaning the pool, and one day it dawns on her. Biff. What do you think happens to the money now? We don't know, really. It could end up with Biff. Maybe not. But how do you think my kids feel about that? So did the plan work? Probably not so well. Because a lot of people say, well, then let's just do all this beneficiary designating and we'll just get it to somebody. You know, and another example that I always like to use is that you use the Mike and Carol Brady situation, is that if you don't do anything, or if you leave it to the spouse. So Mike and Carol were married. Mike had 3 boys. Carol had 3 girls, right? Mike dies. Everything goes to Carol. What happened to Mike's boys? Well, we better hope Carol wants to give them some of the money if she dies, but she may not, right? So, but if she does nothing, it's all going to Carol. So let's say Carol remarries, right? So now where's the money go? Well, we don't know. But what if Carol dies before the new husband does? Now all the Mike's money ends up in his widow's new husband's hands. And then what happens to Carol's kids? Now they're cut off legally. And who ends up with the money eventually? The guy's kids that Mike never knew. And do we want that result? So it makes sense to kind of pay attention, particularly if you've got a situation like that, to make sure that you do plan. Any situation where you've got kids from other marriages and things like that, it makes a lot of sense to at least sit down and have the conversation. So that's how legal ownership kind of works. But to understand that is that it trumps anything that you say in a will or a trust, because operation of law or beneficiary designations are always honored first. And we had a situation like that recently where we had a guy that wanted to leave half his money to his kids and half his money to his grandkids, but he didn't change his beneficiary designations, and his kids ended up getting most of his money, despite his pretty vehement wishes that he wanted something else, but didn't get the stuff changed before he passed. And so it can cause some problems. So we ask people to kind of think about that. So let's talk about a will, okay? So a will names who gets your stuff and who's in charge. So in Michigan, we call your executor your personal representative. But a will only controls what you own in your name when you die, and it must go through probate. So when we go back here, the only thing, as we talked about this, the only thing that my will had any control over was an account that's in my name alone. So, you know, what we see as typical, what we would call probate assets, are those accounts that are in your name alone with no POD or TOD designation on them. Your house, for example, your stuff that you have around your car, those are all assets that people oftentimes will own in their name alone, particularly if they haven't done planning. So they become what we call probate assets. And if you have a will, the will controls how those are distributed and who's in control of gathering all those assets, paying all your debts off, making sure your funeral gets paid for, going through the probate process, and then ultimately distributing your property. So, and sometimes people think if they have a will, they're going to avoid probate. Well, a will signs you up for probate. You got to have, you got to have two things. You got to have a will and you got to have probate property. And then the will controls that probate property, but you have to go through the probate court to get that done. So let's talk a little bit about probate. So probate's a legal process. Again, it's the state's rules, just like a guardianship and a conservatorship is. It can be kind of cumbersome. If you want to open probate, you need a valid will. If you don't have a valid or self-proving will, sometimes you got to go to the judge and have him admit it and prove it. So you sometimes need a lawyer to go in and basically proffer the will to the court with what we call parole evidence to prove that it is indeed your will. A stack of legal documents with an affidavit included in it, your death certificate, $175 to open the case, $12 for your what we call the personal representative's letters of authority. And then you've got to publish notices to creditors, those type of things. So it's kind of a cumbersome, daunting process. I had a woman who has a master's degree. Her dad passed. She came into town, went down to the probate court, and she drove right from the probate court to my office and said, I can't do this. You got to do this for me. I don't get it. And so it's a cumbersome process. Throughout that process, every interested party in the process gets served every piece of paper related to the proceeding. So, and we'll have sometimes you got somebody that's got like 15 heirs. Every time we push one piece of paper out of our office, we've got to push 16 pieces of paper out because we got the one that goes to the court and then the 15 that get distributed to everybody else. So it's a very cumbersome paper-based process. In Michigan, there's a delay related to it. It's usually it's 7 to 9 months, but in Michigan, it can't be less than 5 months. And we find typically a pretty clean estate, it takes about a year to do what we would call a clean estate. We have other estates where it costs You can see this kind of the bottom, 5 to 20% of AARP. We've got one we're working on now that my guess is going to be between 15 and 20,000 to administer the estate through the probate process. The controls with the court, it's a public process. So when you stand in line at Meijer and you see the Inquirer there that says Priscilla Presley got $20 million this year, the reason they know that, or Michael Jackson's kids got X amount of money, is because they can go to the probate counter in the county that they died, ask for the probate file, and it's a public, that you can open it up and look at it. So it's a public process, and a lot of people don't want their business shared publicly, and it's costly. So administering a trust, we'll talk about trust in a little bit, is expensive, but typically probate is much more expensive. And if you have a trust, it's private, and you only serve, the people that get our information are the people you want to get the information, not everybody who might be involved. So, I mean, who is associated, I should say, or interested in the proceeding. So this is kind of the point of the meeting when we talk about this, is like, how many people want to sign up for probate? And virtually nobody raises their hand here. So if everybody wants control and access, nobody wants to go to probate. And I will say this, there are situations where it makes sense to use the probate process, particularly if you have minor children, because we want to have a guardianship nomination that the court's going to honor, which is typically embedded in a will. So we'd admit the will, and we want to have, if we're leaving money to kids who are underage, if we haven't created a trust, we're going to at least want to create a trust for those kids when you pass away, so everybody can get their money when they're 18. And Jeff, who's on the call, probably knows what I would do if, what I would have done with the money at 18, and it probably wouldn't have been good. So, so hopefully you can appreciate that. So, so let's talk about how you avoid probate, because we do, probably 95% of the planning we do is to avoid the probate process. So, and oftentimes what we use is a trust. So let's talk about what a trust is. So a trust is basically a contract, and it's a contract between three parties. The three parties are the person who makes the trust, often known as the trust maker, the grantor, the settlor, the person who decides what the rules of the trust are, what's going in the trust. So that's the first party. The second party is the trustee, and that's the person who's responsible for managing the trust according to its terms, and also the Michigan Trust Code, if it's a Michigan trust, and the beneficiaries. So they're the people that are going to benefit from the trust. So there's really three types of trust. There's what we call a testamentary trust, which I kind of referred to before, which is a trust that's kind of embedded in a will. So it still requires that you go to the probate process. But the most prolific, or the ones we see the most, testamentary trusts are these, what we call a testamentary trust. That's embedded in the will, are ones when you have minor children. So if you wanted to do a testamentary trust, it's a trust that springs out of your will, and it only starts when you're already dead. So that's why the other ones are called living trust. So three things need to happen in order for you to have a testamentary trust. You have to have the will that defines what's going to happen, that the trust can be created. You have to die, and you have to open probate. So we haven't avoided probate, and it doesn't. So those are typically there for two reasons when we use those. Again, for minor children, so that we can manage that money for them until they reach a certain age, pay for school, starting a business, but make sure they don't get all the money plopped in their lap when they're 18 and then fritter it away. The other one is that if you have a disabled spouse, there's some, and they happen to be in Medicaid long-term care or on some other governmental benefits, that we can pass assets to a disabled spouse via testamentary trust and have it not count against them for means-tested governmental benefits. So there's a couple of situations where it makes some sense. In most situations, we don't use those. What we do use a lot are what we call living trusts. So there's two types. There's a revocable trust and an irrevocable trust. And so I've talked to you a lot about the rule book. I showed you my wagon, and we're going to talk a little bit about instructions right now. So, why do we use one of these trusts? Well, if I have all these boxes, so these three boxes represent your stuff. So this would be your house, this could be your bank accounts, and this is your retirement fund, let's say. So if I have those all outside, and if I'm just carrying those things around myself, and I trip and fall on the pavement, and those boxes hit the ground, who picks them up? And so that becomes a big question in some of the things we've already talked about. Well, it depends, because if I don't have a power of attorney, then somebody's got to go to the court and get a conservatorship. And then the judge's going to decide who the conservator should be and what the rules are to pick all those boxes up and figure out what happens with them, because I'm no longer able to make the decisions about that property. If I have a power of attorney and I'm disabled and can't make, or incapacitated and can't make those decisions, then the person who's I've named as my power of attorney would have authority to do that, and they would do it. Hopefully, I'm going to have one of two kinds. I'm either going to have a stock power of attorney that doesn't have instructions in it, or I'm going to have this enhanced power of attorney with instructions that includes asset protection powers, and that person would pick it up and they would manage the property according to my rules. So you have that. And then if I'm alive and well, hopefully I can pick it back up myself. And if I pass, it kind of depends. If I trip and fall and I die, then we could go back to that same conversation. Do I have a will? How's my property owned? Do I have beneficiary designations? All those sorts of things. So what we propose to you is that if I put all my boxes in a wagon and I'm walking down the street and I trip and fall, what hits the ground? Just the handle, right? And then we attach to that handle a book of instructions that says this is how I want all this property. So the trustee, we know that, because I'm typically the trustee of my own living trust, can no longer, I can't act anymore, but I've named a successor trustee. They've got my rule book and they manage all my assets according to my rules. So they would, I'm going to put in my rules of how I want to do that. So let's go back so that you understand kind of how that works and why we think this is a good option for people, is this. So a revocable trust is just that. And this is the trust that most people that do have trust have. And it is fully revocable. You can make changes to it whenever you want. And I'm going to show you some examples a little bit later of how these can work, that we can do asset protection. So you can have asset protection. So it's what we call an open box trust. You can go in and make changes to it. You can go in and get anything out of it whenever you want. And typically, while you're alive, you're all three parties to the trust. You're the grantor or trust maker. You decide what the rules are and what goes in. You're the trustee. You're the one who's responsible for managing it, and you're the beneficiary. You can go get the stuff out of it whenever you want to get it out, get the money, the property out, in and out of it whenever you want. So, but it's a great tool so that when you let's say you pass away. We're going to talk about predators and threats to your trust in a little while. We can create rules inside that trust that say, I want the money to go to my kids, but not until they're 30. But I want this person's going to be appointed, whether it may be their parent or guardian, who's going to manage that money for them until they turn 30. Or I want it in a discretionary trust because I have a daughter-in-law that I'm not so fond of, and I'm a little bit worried they're going to get divorced, and I want to make sure she doesn't plop all that money in my kid's lap so that she files for divorce, that half the money ends up in her hands. Or we talked about that Mike and Carol Brady situation. If we got separate kids, we can put all those rules for all those situations, and that's kind of when I showed you my design meeting earlier. That's what we go through. We talk about each and every person in the family, how they're going to benefit, what their situation is. And we can create all those rules. If I pass and my wife gets remarried, if I pass, if my kid gets divorced, if my kids go bankrupt, can we protect these assets so they don't go right to the nursing home, to somebody in a lawsuit, or to some bankruptcy creditor? All those kind of things. We make all those rules inside the trust, put them in the rule book, and that's what governs what happens to my stuff. So we also then integrate it with our healthcare directive documents. So the trustee's directed to make sure our healthcare is taken care of, our money's being used to pay for our care, maybe qualify us for Medicaid and protect the assets for my spouse and kids after I'm gone, so on and so forth. If I have charitable intent, all those sorts of things. We put all those rules in one living document, and it starts the day you sign it, while you're alive and well, through any incapacity, whether temporary or permanent, and then after you pass. So what we end up saying, we kind of say this, and so then if we ever have to, you can make changes to it whenever you want. Obviously we want to build one that's going to last for a while, because you want to be calling me up so that I'm sending you a bill all the time to make little changes. But it's completely malleable, flexible, and it gives you a management tool to manage your assets and to create and deal with all these other situations that can or may happen. So like the car wreck and you hit the other person and kill them, all those sorts of things. So it's really a kind of a cool tool to be able to use for as a management tool. What we like to say is that, when we have this, we never have to go to the courtroom to get decisions made or have meetings. They're either in our conference room at our office or the family room at your house. We keep it all in the family, and we don't have to serve everybody all these documents. It's a private document. It isn't made public. It isn't ever made public unless somebody comes in and challenges the thing, and we have some provisions we put in there to ward off challenges too. So, but the problem with a revocable trust is that it doesn't create any asset protection while you're alive. Okay, so one of the things we're going to talk about here in a little bit is Medicaid planning, and the other thing that I talk about, some people own businesses or they own properties, and when they own properties, maybe they own them in an LLC or something like that, and that business has some protection from the inside out, but it's not protected from the outside in. But the bigger thing is, so we've got these asset protection issues, but we also want to plan for long-term care and try to protect, my power of attorney and my trust, I have both, and I'll tell you why I have both. Careful, keep me in the most restrictive environment as long as I can. When I get to the point where I'm pretty much unable to make decisions anymore, qualify me for Medicaid as soon as possible and protect all the assets for my wife and kids. That's how I want mine done. So if I have an irrevocable trust, the irrevocable trust that we use provides asset protection. It also protects that money from Medicaid and DHHS. And the trust that we use is called an IPUB trust. We'll talk about that in a little bit, but that trust basically allows for you to make changes to the trustee structure, the beneficiary structure, and the means, what we call the means, manner, and method of distribution. So it's not completely irrevocable. It's only irrevocable to one or two things. So to qualify for an irrevocable trust and for an asset protection trust, you have to give up right to the principal that you place in that trust. So, so the best example is this house that I'm sitting in is an irrevocable trust right now. So I'm the trustee of the trust. I get to manage it, but I can't sell the house and take the money back. I can sell the house and buy another house, or I can sell the house if I want to downsize, buy something for less and invest the rest of the money. And I can take, my trust is I can take any income generated by any assets or property that I have inside my trust. So I can take the income from it. And I may or may not want that. So there's only certain people that qualify for that, but for people in the right situation, it's a great tool, still provides a lot of flexibility and control, and gives, as long as you've got income streams to support your lifestyle, it can be a really excellent estate planning tool. So we use these in place of a will, because these are what we call probate avoidance tools, because all these assets are held inside the trust. So we've already determined what happens to when you pass. So you don't own anything in your name when you pass. So my checkbook says Jack and Becky Wires, trustees of the Wires Family Trust, #1. And so we write everything's inside the trust, and it's inside my rule book. So if something happens to us, our trustees got to manage it according to our book of instructions. So that's important to kind of understand about what trusts are. One of the things that we used to use a lot of irrevocable trust for, and this has changed in the last 15 years, were trusts for people that had taxable estates, and that's changed a lot now. And we'll talk about that in a little bit. But we use these trusts as probate avoidance tools and as management tools, so that we have kind of a continuum of management, and we avoid probate at the same time. So, so one of the things we like to do is to see how the way you own your assets affects your will, your trust, or other estate plans. And so this is just kind of a review. And so, we already kind of talked about that. So I kind of got ahead of myself. Let's go back to this slide. Erica, I think I got a different set of slides here too, for some reason. They're a little different. Just make a note of it for next time. I'll work my way through it. But when we talked about these accounts, we talked about how that affects it, is that you could have the best will, the best trust. You could be a 200-page trust, all these kind of things. But if you use these beneficiary designations, and this is what we call trust funding, and Kat's title is our funding coordinator, is to make sure that we get all the boxes in your trust. So all your boxes in your wagon. So if you don't have all your boxes in your wagon, you can still end up, because remember that these types of legal ownership trump what your will says, what your trust says, any of it. So we would want to direct assets to your trust while you're alive, all the ones that we can. And then there's the assets that can't be owned in your trust are your 401k or IRA assets, and we typically direct those to your trust when you pass. Those are a little bit different creature in the eyes of the law. So we deal with that. And then that's why when I said I have a power of attorney, because I need my power of attorney to deal with my IRA. So if something happens to me and Becky needs that money, she can use my power of attorney to deal with that, because I can't have it contained in my trust while I'm alive. So let's go ahead and move on and talk about, so just hopefully you got that concept that how, you can have the best will, the best trust in the world. If you've got beneficiary designations that say something else on all your different assets, the will and the trust aren't going to touch it. So they're going to go directly to who you said, because that takes first priority in your, so that becomes a very important piece how you do that. So we like to do a funding review with everybody. That's a real big piece of our process, because we see a lot of people that come in that have really well-written trust. An example, I had a doctor come in about 2.5 months ago now. He came in with this stack of paper like this. And he told me that he had powers of attorney, and he had a stack of paper like this. And I'm like, Doc, it was in an envelope. And it looked like it had never been touched. So I said, Doc, I'm pretty sure you got more than powers of attorney there. I said, they can be kind of long, but I'm pretty sure there's something else in there. He said, well, what do you think we got? And I said, when did you have that done? He said, 2003. I said, well, it looks like you got it last week, because the paper isn't even crinkled. So I'm pretty sure you haven't looked at that since 2003. He said, no. And I said, well, based on the estate planning environment then, you and your wife probably have separate trusts. You've each got a pour-over will. You've got powers of attorney, and then you probably got something in there, another envelope or a separate document called funding instructions. And he says, no, I don't think you're right. And I said, pull it out. So we pulled it out, and I'm not a genius. I just know how people do this. And sure enough, they had separate trusts, because that's how you did estate planning in 2003 to avoid estate taxes. And they had all the other documents we had predicted that they had. And he was kind of shocked. And then I went on to say, so did you split your house in half and put half in your trust and half in her trust? And he looked at me like I was nuts. And I said, that other envelope in there, that's your funding instructions. Open it up and look at it. And it told him, take your house, indeed half to one trust and half to the other, and all these kind of things. People don't do it. And then your life changes. So I've had the other people that came in and said, I got the trust. And I'm like, what's in it? And they said, our house. And I said, that's funny, because we went and looked at the records, and the tax bills are going directly to you, not to you as trustees of your trust. And they said, no, here's the deed. Here's a deed. They were searching through all these papers. And here's a deed that says my house is in the trust. I said, that's not the same address that you gave me. And they went, oh my gosh, that's our old house. We sold that one and bought a new one. So as your life changes, once you put this thing in place, you got to make sure that as you acquire new assets, as your family situation changes, that you're constantly and continually updating this thing and making sure that it's going to do what you want it to do. So let's move on and talk about your predators, because I think these will surprise you. So let's do this real quick. We're going to talk about 5 different things here. The government, and we already talked about that, so we're not going to talk long about that. So if you have to go through guardianship, conservatorship, or probate, you're using their rules. It costs more money than it costs to do it yourself. And it's a public process. So typically we think that's kind of a pretty predatory environment, and it's not something that we certainly recommend. The next one is taxes. Next one's lawsuits. Your family members, which is kind of one that surprises people a lot, but some people understand it better than others. And then nursing home and care costs, which we spend quite a bit of time on. So we talked about the government piece, so I'm not going to spend any time on that. Let's talk about tax provisions. And yeah, see, Erica, these are older slides. I clicked on the wrong show today. So this has changed a little bit. I'm going to tell you folks what it is, and then maybe you guys did they have slides? They don't? Here, I'm going to unmute you for a second. I can't get you unmuted.
Hold on. Okay, can you hear me?
Yeah.
Okay, yeah, we do not send out the PowerPoint ahead of time. We can send it before, I mean, after this, but yeah, I don't know
Yeah.
how we
Oh,
got the wrong version.
I got
Technology.
this is the old PowerPoint. So I'll tell you what, folks, give me just if everybody wants to take a short break, give me 2 minutes. I'm gonna pop out and go get a different set of these slides real quick, okay?
Let me make
Just
sure.
bear with me. Eric, are
John.
you there?
Yeah, I was just gonna say the one that you opened, did it say Jack's copy?
No. I'm not finding that one.
Okay, give me 1 second and it should be.
I mean, everything was downloaded on the 28th, so I can't tell. When I go to 7 threats, I had a flyer, flyer, overhead, PowerPoint, and that's the one I clicked on, and that's it. I just have that old one. Can you email me real quick
Yeah, the problem is the one that I'm looking at is the one I did put in Dropbox. That says Jack's copy.
I don't have one that says Jack's copy.
Okay, I'm sorry. Give me 1 second real quick. I just want to compare that slide. Can you tell me what slide you were on?
Yeah, see, that's the EPLC one.
I got it right here. Hold on.
So can you just email me the one you're on?
Yep.
Then I can just go get it and open it.
Yep.
I only show one PowerPoint in my 7 threats. That's it.
My computer is going so slow. I'm sorry. It's just lagging.
All right.
It's coming. It's coming. It's attaching. It's coming. Subject sent. Okay. Okay, it's sent.
You sent it?
Yep, just now.
There you go.
So sorry, everyone.
That's okay because it kind of knocked me off the beam. So I think you probably figured that out, right?
Yeah. Okay. Do you see it? You got it?
Okay, here we go. So let me go back here. You guys there?
Yep. I'm here.
Okay. Now I got to figure out how to screen share this thing. Oh, here we go. Perfect. Which one is it now? Ah, there. Got it?
Okay, we see ya.
Okay, now let's see if I can get through it. It's not letting me. Yeah, see?
There.
There's my question.
Yes. I thought something was weird. Okay.
Yeah, so we got caught a little off guard. I've been trying to make it up as I go here a little bit. So Okay,
Yes, that's what I was looking for those. I
all
don't know
right,
what happened.
okay.
Technology. I'm
All
so
right,
sorry.
yeah, so is everybody back on board with us?
I think we lost.
All right. Okay, so we talked about the trust a little bit, but as you can see, so our open box, because I want to come back to this, is our revocable living trust. We had three versions of this irrevocable trust, and that's just something. I got to go too deep in the weeds to spend time on it. Typically, what we would do is when we do a vision meeting, we'd have you in and we can talk about whether it's something that is applicable to you and would fit your situation very well. And for those of you who have, we're going to talk about this in just a second. For those of you who are single and have more than $11.5 million, and those who have more than, or if you're married and you have more than $23 million, you'd use this trust on the bottom left here. So if there's any of you in that situation here, feel free to call me when we're done. But anyhow, so let's go back and talk about this. So this is a slide we left off on. All right, and I'm going to get going. So just a misconception I like to clear up for people is gift tax, because people think that if you give a gift, you pay tax on it. A lot of people think that, and really the way the gift tax work is that when I referral to the 11.5 million, you can see here under the lifetime exemptions for 2020, a single person, unless their estate exceeds 11.58 million, they don't pay any federal estate taxes. So, and that was doubled and it's kind of sunsets at the end of 2025 with Trump's ACA, the ACA, that the Tax and Job Cuts Act. Tax Cuts and Jobs Act, isn't that true? Does that sound bad? Tax and Job Cuts. But what the gift does this is, so if I give 15,000 bucks to Erica this year, I don't have to report it all. I don't pay any tax, nothing. There's no reporting required. If I give Erica $25,000 this year, if I gifted her that, I have a $15,000 exemption. So I have 10,000 above that gift, and I have to file a gift tax return on that $10,000. The effect of that is nobody pays any tax on that 10,000. It just reduces my 11.58 million to 11.57 million. So it just takes your lifetime coupon that they give you before you pay taxes and reduces it by any gifts in excess of the per person per year exemption that you make. So that's why they want the return filed, so they can start deducting it from your coupon. So I always tell people here, if you got $1 million and you give somebody 50,000, you know, if you give away, you know, if you can't give away 11.58 million, you don't have to worry about estate taxes. And it's probably something less than that because we know it's going to pull back at the end of 2025. But if you don't have 500,000 bucks to give away, you can't give it away. So, you know, oftentimes we talk about gifting, but gifting can have very negative consequences when it comes to long-term care planning. We'll talk about that, but just I like to clear that up. So, and then for as far as the lifetime exemption for 2020, it's 11.58 thousand for an individual. If you're married, you can support your spouses to double that essentially. So if a husband and wife die both in the same year, this year, their lifetime exemption would be 23.16 million. So you have to have a lot of money to pay federal estate taxes. Typically the way there's an unlimited spousal exemption too, so that if you die with 10 million, give it all to your spouse, or 20 million, give it all to your spouse. And she were to, if she didn't, let me do this even better. This is a better way. If you gave her 30 million and she spent it down to under 23.16 million when she passed, she pays no taxes. So it's a hard thing to get to. It affects about 1 in 1,000 people. And quite honestly, we don't really do a lot of that planning because there just aren't that many people. And when we do, oftentimes it gets pretty complex, and that's not really in our wheelhouse, and we'll refer that out. So the other thing I should just point out is in Michigan, we used to have an inheritance tax on September 1 of 1993. It wasn't, they called it an inheritance tax, not an estate tax, because they didn't tax the estate, they taxed the people inheriting it. That was abolished in September 1 of 1993. So unless you have this much money, estate taxes are a thing of the past. We do different kind of tax planning now, what we call step up in basis planning, to make sure that assets are being used the most efficiently while you're alive. And then when they pass, there's the least amount of capital gains tax paid after you pass. So that's kind of the tax planning we do now. So that's not, the estate taxes aren't the threat that a lot of people think they are. Lawsuits. So again, any business lawsuits, personal, home, property, auto, those are threats to you now and your beneficiaries after you die. And the best example I can give of this is I have some uneven pavement here out in my sidewalk. If the UPS guy comes up the sidewalk, trips and falls, cracks his head open, and ends up in a coma for the rest of his life, and his family sues us for 10 million, all of my assets, if I haven't done anything else with them, including my house, because my wife also knows that about the crack in the sidewalk, all of those would be attachable in a lawsuit. So if I leave the house to my kid and somebody trips over it when she owns it, that can be attachable in a lawsuit also. So you can lose it all. So we want to make sure that we've got planning done, or at least that people are aware of that, and that they've got the opportunity to try to plan around that if they'd like to. And then family members. And so we kind of talked about the first one, the Brady's. So, how that can be a threat, and you can end up with a really unintended or unwanted result. And that's kind of what when we talk about these predators and threats, is, unwanted and unintended results. We've all worked hard to accumulate money in our lifetime. And if this virus doesn't take it all away from us somehow, we want to make sure that to the extent we can, we've got that protected and that money goes where we want it to go. If something happens to us and either incapacitates us or kills us. So we've got that piece. We talked about the remarriage. If Becky decides to marry Biff, and so we've talked about those kind of things. Where does my money end up? The family's bad luck, so you get sued, like the car accident we talked about. Somebody goes into the nursing home, like we talked about before. If you have a child that you leave money for and they get divorced, we've seen that happen before, where somebody, they said, yeah, the marriage isn't that good. The kid inherits $500,000, and a month later the divorce papers come, and half of the money ends up in the hands of the unwanted in-law, so to speak. And then we've got family irresponsibility, or vulnerabilities, I should say, and one of those is if you give a kid $1 and he spends $3 every time you give it to him, or the 18-year-old that buys a little red Corvette. Sometimes it makes sense to manage that money and make sure all this money is managed so that these things don't happen. And then oftentimes, and we've had this situation where we had a guy I was helping him administer his parents' trust, and I walked into my conference room and he was muttering about, he basically, I heard him mutter under his breath, "I can't believe you filed bankruptcy again." And I said, "What do you mean again?" And he said, "Well, my brother, we all the 4 siblings each inherited about $500,000 from this estate, and one of the brothers had filed bankruptcy, and we had made partial distributions of most of it, but the kid had already filed bankruptcy." And I said, "What do you mean again?" And he said, "This is the 3rd time." And I said, "Well, we didn't do the plan for him. We were just helping to do the settlement." But it's like, didn't anybody ever have that conversation with him? It's like, people that file history repeats itself. If somebody filed bankruptcy twice, just because you gave them a bunch more money doesn't mean they're not going to file it again. So, we may want to manage that. And then addiction is one, as in my Dave Zampano, the head of the Lawyers of Purpose, would say, the fastest way to kill an addict is to dump $500,000 on them and see what they do with it. So, we kind of use this kind of in jest or tongue-in-cheek saying is that you never want to give anything to anyone you love without having really thought about it first in deciding whether or not that money should be managed or not. So that we've explored all the different situations. So when you come and talk to us in a vision meeting or design meeting, those are things, all situations that we want to talk to you about. And every family's different. They just are. And some we really don't have to do a lot of that planning. Some we have to do a lot more. So it's just kind of how it works out. And then the biggest, what we consider the biggest threat is the cost of long-term care, because we see, as you just drive down the road and see, they're building more and more of these facilities. As the baby boomer population bubbles out, there's just more and more of this. It's a pressure on society as a whole, on families, and on individuals. And Erica and I have done we did some different calculations, some Googling, I guess. And we asked what the average cost of care at home is for people who get home care. And, what we got back from Mid-Michigan was between $500 and $5,000 a month. The average cost for assisted living between $3,000 and $6,000 a month for an assisted living facility. And that typically is the rent there. It's not really the ancillary or a la carte services. And the cost at a nursing home is between $7,000 and $13,000 a month. So as you can imagine, they talk about Alzheimer's and these dementias, or memory related diseases. They're saying the average stay for these things is approaching 5 years. So if you're paying $100,000 a year for 5 years, that can put a pretty substantial dent in your estate. So if you got kids you were trying to leave money to, or any loved ones, friends, a spouse, in particular, you could really put your spouse in the poorhouse by having an extended stay. We have a client whose mother-in-law passed after 17 years in the nursing home. So it can be get really expensive. The state of Michigan has to publish what they call a regional divisor, which is the state's estimation, Department of Health and Human Services estimation of what the average semi-private nursing home room costs in the state of Michigan. And this year it's $8,618 a month. So it's just over $100,000 a year. So how are you gonna pay for that? So, and you have, what are our options? Where do we go to be cared for? We can be cared for at home. We could be cared for, we can be cared for when we're living in an independent living facility, at an assisted living facility, or in the nursing home. That's kind of that continuum of care we see. Some, examples that I give. So before my dad passed, and my twins were born, so it's kind of an interesting thing that I was able to kind of help him. Then my twins were born, and then I'd have them in the middle of the night. My dad kept falling at night. So we ended up getting him around the clock care at home, which cost about $12,000 a month. So that was expensive, right? So after the babies were born, he kept falling at night, and I'd get the call from his Med Alert people, and I'd say, hey, you got to send the Meridian Township Fire Department out there. I got 2 crying babies in my arms. I can't do anything. I can't go do it. And it was happening a lot. After about the 5th time, when I was on the phone with the Meridian Township Fire Department guys, one of them got on the phone and they said, hey, Jack, you better take some steps to protect your dad. I don't want to have to, we don't want to have to call APS on you, but he needs to be moved to an environment that's safe for him. And I said, yeah, I know. I should convince him of that. So we ended up moving him to the Willows into assisted living, so that was $5,000 a month. And then he kept falling there because they're not staffed well enough to watch this guy who was not their most compliant patient and pretty stubborn. He'd get up and walk and kept falling. So then we brought in the round-the-clock caregiver into the assisted living facility. So now we're at $17,000 a month. So you can see how this can get way out of control really fast. And so we will want to be able to plan and maximize options, because one of the things that we want to do when we go back to that instruction manual is we want you to start thinking about who do you want to care for you, where do you want to be cared for, how you're going to be, so who, where, how, which would be kind of the personal care plan piece, and then how you're going to pay for it. So those are all things we want to have included in this plan. So, so those are kind of our options. We're going to talk a little bit about that in this part. So when your health fails and it's never expected, what happens? So how do you pay for this? Well, if you're paying for long-term care, I only know of 3 ways to do that. And I guess the first one's kind of 2. So either you can pay for it or your family members can pay for it. Long-term care insurance can pay for it. Unfortunately, when I ask for a show of hands on long-term care insurance, we see about 10 to 20% of the people have long-term care insurance raising their hands. That gives you some extra flexibility, and if you can go out and find it, there's a lot of different products out there available today, and I always suggest to people that they should explore those. There's also some short-term care plans that can kind of buy some time until you qualify for a governmental program. All those, so there's different products out there, and that's when we talk about at the end here, our threat number 6, we're going to talk about having a professional team together, is that, you should be working with or talk to somebody and exploring those kind of options and see if there's some kind of affordable way to allow you to be cared for somewhere other than the nursing home over the long haul. So, and then the last one is the government pays, and we're going to spend a lot of time talking about that. So if the government pays for care at home, or it's kind of anywhere through the end of assisted living. So on the continuum until you get short of the skilled nursing facility or the nursing home proper. There are certain VA benefits. So if you're a veteran, you can qualify for those. I'm not going to spend a lot of time on that right now, but it's something that we should, that's worth discussing if we were to have a vision meeting, if you're a veteran or a widow of a veteran, how you might access those benefits, because you can access, depending on the situation, up to about $27,000 a year in benefits for home care and those sorts of things. And then there's Medicaid benefits. In Michigan, there's 3 different programs. There's Help at Home, there's the My Choice Waiver Program, and the PACE program, which is the program for all-inclusive care for the elderly. All of those have bright line income tests. So if you can't qualify from an income standpoint, you can't qualify for those programs. Unfortunately, Michigan's law is set up right now so that it forces a ton of people, particularly people that have some income, into the nursing home if they want to be, if they want the government to pay for their long-term care. And a lot of people just can't afford it themselves because it's so expensive. So you can go to a lot of nursing home directors and say, you go to Keith Fisher over at East Lansing at the Willows and say, Keith, how many of these people could be cared for at home, or the director up here at Dobie Road? And they say maybe 40–50% of them could be cared for at home, but the reason they're here is because Medicaid, the only way Medicaid will pay for it is if they're here. So, that happens a lot. They all have eligibility requirements. So there's an income test, there's asset tests. You have to have medical need to do it. And it applies to all those. So we're going to talk about those a little bit. So you may have heard Medicaid myths, and this is one of the reasons why we think it's important to specialize in this piece of law. You may have heard they can take your home. You may have heard they can't take your house. You may have heard that you have to give away your assets to protect them. And if you give away your assets, you have to wait 60 months to qualify. A lot of people know about the 5-year or 60-month look-back rule for Medicaid, and basically it's a very misunderstood rule, but basically what it says is that they're going to look back 5 years in your financial records, and if you've given away anything or sold anything for less than fair market value, they consider that a divestment, and it becomes a penalty when you apply for Medicaid. It doesn't necessarily say you got to wait 60 months to qualify. Depending on the size of the divestment, sometimes you do wait 60 months, but typically you qualify sometime in between there. It just creates a penalty period on the front end. So, but the important thing to understand about Medicaid is this, is that the Bridges Eligibility Manual, when printed out, is about that thick. The administrative manual is about that thick, and the glossary is about that thick. And it's just a set of rules and exceptions to rules and exceptions to the exceptions and exceptions to the exceptions to the exceptions. And our job is to know those rules, and you'll see why it's important, because there's a lot of money at stake. And if you use those rules like your tax guy would use the rules, you can save and protect a lot of money if you have somebody that knows how to use those rules. And we have an article, I don't know if Erica sent it out, but it talks about don't ever let the nursing home apply for your Medicaid benefit until you've talked to a lawyer first. Because the nursing home can't do this kind of planning for you. The Tri-County Office on Aging can. In Michigan, as attorneys, we're the only ones who can do this Medicaid planning that can protect a lot of money for people. So I'm going to give you a couple quick examples. So this would be what we call vertical planning. So these are people that are healthy, and they're both, this is kind of a fictitious one. It's Mr. and Mrs. Richards. They've got a house they have about $150,000 in equity. They have cash of about $152,000 at the bank. Their car and their miscellaneous stuff around the house, their household stuff, if you sold at a garage sale, you had to put that all together, it would sell for about $25,000. And they had stocks and investments worth $250,000. And what they want to know is, if they give away their assets now, how long would it be till they could qualify for Medicaid? And could they protect their assets sooner? So first of all, before I switch to the next slide, we're going to go back a little bit and understand this, is that their home, their cash, their car, and their stocks are all attachable in lawsuits. So anytime, if they were to be negligent and cause a wrongful death or something like that, if they did it together, one of them did it, the cash, the car, and the stocks go. If they're both involved in it, then everything goes. So they have no asset protection. So what we end up doing for them is we create this plan. So they've got the whole $577,000 that's at risk. We create this plan for them, and we're using one of those irrevocable trusts that we talked about that would immediately protect $395,000 of the $577,000. And then they'd have a balance at risk of $182,000. But that would be for 3 years. Every month after that, they would protect another $7,500 until month 60, when it's all safe. So if they do this now, when they turn 80 in a day, so we're saying they both just turned 75 today, and we put this plan in and got it funded. 5 years and a day later, one of them needs to go into the nursing home. Medicaid asks them what kind of assets they have, and they have nothing. It's all it's all protected, and it's kind of stashed in this irrevocable asset protection trust. So they would immediately qualify, and Medicaid would take the person who goes into the facility, all or some of their income would go towards the cost of the care. We can oftentimes protect some of the income from the spouse using those rules for the community spouse. But Medicaid would fill in the gap and pay all the other bills, and we would have protected the whole $577,000 for the community spouse. And if the community spouse passes, then everything goes to their kids. So we can do those kind of things if we can do what we call vertical planning while you're healthy, and we know that it's for all intents and purposes, we think you got a few good years ahead of you. The other type of planning we do is what we call horizontal planning, unfortunately, and that's when you're lying on your back in the nursing home, or you're about to get discharged from the hospital and you're counting ceiling tiles. And the other kind of horizontal planning is the really kind we really don't like to do, and that's when you're looking at dirt. So, but this is a situation, this is a real live story. I mean, the numbers have been rounded, the names have been changed, so on and so forth. But Mary Smith's daughter, her daughter went to preschool with Willa, who was knocked on the door at the beginning of the meeting. And one day Mary Smith called our office, and she said to Erica, "Hey, Erica, I need to talk to Jack right away. I just got to get him, ask him if he can do something for me very quick." And so she gave me Mary, and Mary, I got on the phone with Mary, and she was very kind of agitated, and she's like, "Jack, I need you to do me a favor." And I was like, "Hi, Mary, how are you?" She's like, "No, I need you to do me a favor right now." And I said, "What?" And she said, "My mom had a stroke. She's in rehab, and they're basically telling us she's never going to be able to come home." He said, "So I want to, we talked to my dad's buddy, he's a lawyer, and he said we have to file for Medicaid immediately. So what I need you to do is call my sister and tell her that's the right thing to do." And I said, "Well, Mary, let me ask you some questions first." And she was really insistent I just make this call. And I said, "First of all, I'm not going to do that." I said, "Because it's giving legal advice, and I don't know enough about the situation." I said, "So I at least need to know more about the situation. But I think, let me ask you these questions, at least answer these for me." So I said, "Well, how much did this guy tell you how much are you going to lose?" And she said, "Well, he's told us we could keep the house." And I asked her, I said, "Well, is it titled in your mom and dad's name?" And she said, "Yeah." And I said, "Well, then you can likely keep the house." And then she said, "Told us we keep one car." And when there is only one, I said, "Yeah." And then he said, "There's another." I said, "But what about this other 380,000, 105,000 in cash and 275,000 in stocks and investments?" She said, "Well, he told us we could keep 130,000 of that. And that's the reason we need to apply right away, so we can get into spend down mode, so we can spend down to that 130 and get Medicaid on the bill, on the hook." And I said, "Well, I don't necessarily agree with that. I think there's something better that can be done with that, but I don't know the whole situation." I said, "How much is this guy going to charge you for it?" And she said, $13,000 to do the planning. And I said, is he in Oakland County?" And she's like, "Yeah, how'd you know?" And I said, "Because that's what they charge in Oakland County to do this kind of stuff." I said, "We don't charge that much here in Michigan. So you're probably paying a little more." I said, "But I'm concerned because I think you can get a much better result than that." And I said, "I have a 4-page form. It'll take you about a half hour to sit down, 15 to 30 minutes to sit down and fill it out. Would you do that for me and send it back to me? And I'll tell you what I think you can do." And so she reluctantly finally fills the thing out, sends it back to us, emails it back to us. I run the numbers, and we look at the rules, look at everything they've done. And it turns out that they would qualify for what we call a Medicaid compliant annuity that essentially converts excess assets into an income stream for Mary's dad, and returns that all to him over a 4-year period. And we were able to charge her about 70% of what they charged her down there, but we protected, other than that 250,000 in excess assets over the 130, we were able to protect all but our legal fees for dad. So it was a much better result. So when it was all said and done, and I will say this, so Mary's like my best friend now. Dad's almost got all the money back through the annuity. Mom's in the nursing home still, and she's doing okay, but she's not coming home. And so everybody's pretty happy. But as Erica always points out, is the real moral of the story is here, though, we asked Mary who the lawyer was. And she said, "It's my dad's old golfing buddy. He's a real estate attorney." So the moral to the story here is this. you don't have to work with Jack Wires or Sarah Reedy or Family and Elder Law in Michigan, but if you hear the word somebody talking about nursing home or Medicaid, have them go talk to an elder law attorney. If you're in the Lansing area, there's a lot of us who have a lot of experience with this. It's big money. We can use those rules to your benefit, and don't let the nursing home just submit the app for you and get you in spend down mode, because it's just the wrong thing to do. So the return on investment we can show on that type of planning is astronomical. I've literally had people say, can I pay you twice, Jack, based on what we did? And one was in a situation like that. And because we can protect a ton of the money using the rules to your benefit. So, and then as another thing that Erica would point out, so first of all, go see a specialist. Don't go see a generalist or somebody that does something different. Sorry about my dog barking. Everybody's numbers are different. So, every situation is different depending on your mix of assets, how they're structured, how they're held. But we can do that analysis, and Erica will talk to you at the end here about creating that, getting us that 4-page form, so that if you come in and do a vision meeting, we can sit down and talk to you about how this would work for you if we were either in crisis mode or in pre-planning mode, either vertical or horizontal planning. So, and we'll do that analysis for VA benefits and Medicaid at no cost. It's just part of the vision meeting process. So let's move on to number 5. So failing to plan when you can. Okay. So, as I said, your options are much better and you have a lot more control. I mean, I think it kind of speaks for itself. But we want you to plan to keep it simple for your family and to have things understand, so that you can understand what's going to happen or the most likely thing to happen, prevent fights, and protect your assets to the maximum if possible, and protect people from unwanted situations, vulnerabilities, lawsuits, all those kind of things. If we plan now, we can make provisions for those kind of things. So we want to make sure that you have control or access, or if you don't, that the person that you want to have control or access over your assets has them if you become disabled or you pass away. So we think that's really important. And if you do it now while you can, it's a heck of a lot easier than trying to do it some other time. So because we end up doing a lot of that because people walk in and they haven't planned, and we got to try to help figure out how to wrestle the beast to the ground and do the right thing. So what's involved? Legal documents, there's those, and we say we're not a legal document production firm, we're an estate planning and elder law firm. So we do planning, and the documents are part of that strategy. You have to have financial and long-term care strategies. Again, how are we going to pay for this? How do we want it to happen, and how do we want it to unfold? And some tax planning. And then, your options are this. You can use the government's rules. The government has their rules. If you come in for your vision meeting, you say, hey, Jack, if I did nothing, what would happen? I can explain that to you. And then you can decide if that's the right route to take. So I've had people walk away and say, yep, then we'll use their rules. And a lot of people are like, hey, when I'm gone, I don't care. They can clean up the mess and they can spend the money out of what's left. But one of my favorite sayings from one of my colleagues on the other side of the state is, just because you can't take it when you go doesn't mean you should leave it in such a mess. So, and people that have had to clean up those messes usually are the next people on my doorstep to do estate planning. So, and you could, the other one is to use your rules, but we can only use those if you create them. So, so you have to take those affirmative steps to create the rule book and create it to the extent that you want to create it. So what do you need? So so as I told you, if you come to your vision meeting, you're going to get 3 options. Okay. The basic plan would be a will with some enhanced provisions in it, our healthcare directive or patient advocate designation or directives. We can't give anybody just the stock one. We just don't feel it in our heart. We can't give them just the very simple grant of authority. We're always going to ask you some questions because we think there's some questions everybody should answer, and it's just conscientiously for the patient advocate that they have those answered. And also a durable power of attorney expanded with instructions. So that would be kind of the basic estate plan. Typically, we're going to do that and use the beneficiary designations we talked about earlier to avoid the probate process. So we have the will as kind of our backstop, but we're only going to employ it if we absolutely have to, so that we can avoid that probate process when you're gone. So that would be kind of the base plan. The next one is when we create, so that's, and then option 2 is really when we're starting to create your rule book where we have really explicit and expanded rules about what we want to do. And that would be everything that you see in option 1, the basic plan, plus a revocable living trust, which is kind of the open box trust. So that's going to include rules for while your life, disability, and death. So while you're alive and well, when you can't act on your own behalf, but it's still alive, and after you're gone, that's what we call the open box revocable living trust. It shifts control at disability and death, maximizes tax planning at death, avoids probate at death, keeps your estate private, so it's not a part of the public record, and does asset protection after death. And we're going to talk, I'm going to give you a couple examples here in just a minute of how these actually work. I didn't bring $2 down here, Eric, because I'm going to do it just with my hands, I guess. So we're learning as we go, gang. And then option 3 is we're using what we call our asset protection trust. And those are known as IPUG, hence the dog there. It's what we call an irrevocable pure grantor trust. And it's trademarked by lawyers of purpose for lawyers with purpose attorneys. It's a pretty unique trust vehicle, and we think it's kind of really a cool tool to be able to use for Medicaid planning and asset protection planning, and particularly for people that have businesses and rental properties or things of that nature. So that does all the things that I just showed you for the first 2, but it also includes asset protection while you're alive. So it gives you most of the benefits of the open box revocable trust. The one thing you have to either give up access to principal and or income. So you understand that when you get there, as people say, well, as I had a guy yesterday, he says, well, I got this trust, I need the principal. And I said, well, what do you need it for? And he goes, my granddaughter's getting married. I want to give some money to my kids for the wedding reception. And I said, they're principal beneficiaries. You just can't get it. You can give it to them. You decide who you can give the principal to. You just can't give it back to yourself. So, and that's what most people, if they were established and been around for a long time, we say, what do you need that principal for anyhow? It's typically for the kids, the grandkids, or some other charitable intent, something like that. And we can do that. We just can't give it back to you. But it protects your assets from predators now. So we have a couple different kinds. You saw in that little diagram when I came back on with the new slides. We have what we call a trapdoor, a sieve, and a faucet. I will explain that to you when we do a vision meeting with you. But it's just the level of income that you want to have access to. That's what it relates. Those relate to once you employ the trust. So let me give you an example of how this works. So I'm going to use what we call a revocable trust. I'm going to use my family. Willa, because she knocked on the door, is going to be disinherited. I'm kidding. But it's easier to use with the twins because I need 4 people to do my example best. But let's just pretend I got $1 in each hand. Is there any amount of money in each hand? Okay. And it's Becky's and mine. So if I put it together as ours jointly. So we can do whatever we want with that money while we're sitting here. We can spend it, we can save it, we can give it away. Right. So if I take that, if we went in to see Sarah and we're doing estate planning, and we decided, we tell Sarah, well, we want to create a revocable living trust or the open box trust. And she says, well, that's fine. We talk about it. We say, well, but we're going to put some certain protections and provisions in there to make sure that we don't have some of these results we don't want. So we put it in the open box trust. Okay. And so when it's out here and I can spend it, save it, give it away, if I have a lawsuit or a debtor or a creditor of any sort of kind, they can come take that money too, because it's available to me at all times. I put it inside this revocable trust, which makes it available to me at all times as long as I'm alive and well. And I can still spend it, save it, and give it away. Same with Becky. And so can our creditors and creditors can come and attach those assets. Okay. So I die, and what we do with this money is we take half of it and we place it into a trust when I pass that springs from it's in our instruction book. It says half of the money is going to go into a trust, and that's going to benefit Becky while she's alive and the kids while she's gone, after she's gone, but it's going to be protected in there. And then we're going to leave the other half out for Becky so that she can come and get it, so that she can spend it, save, and give it away. It's still sitting in a revocable trust for her. So we split the trust into 2 trusts, one that's irrevocable and one that's half the assets and half that's revocable. So Becky, so what we do to make this, so Becky can get at these assets whenever she wants, that's in the revocable piece. And she can't get to the other assets in the trust that we set up for her and the kids unless the trustee says so. Okay. So then that's usually when the surviving spouse in the room raises their hand and says, well, hold it. So you mean I can't go get that money? Say, no, we don't want you to be able to go get that money because we want that money to be protected. And the only way we can protect it is we have to have the right features in the trust to make it qualify as an asset protection trust. But what we're going to do is we're going to make one of your, we're going to pretend my kids are over 18. We're going to make one of your kids your co-trustee, and you have the requisite oppositional interest, as it were, in the trust, such that we can create asset protection, because Becky's got a vested interest in spending all the money before she dies legally, and Presley has an interest, Presley and Paxton have an interest in Becky not spending any of the money before she dies so that they can get it. So we name one of the kids as her co-trustee, and none of the money comes out unless both say the money can come out. So we have this co-trustee structure. So a few months go by, Becky calls up Presley and says, hey, Presley, I need to talk to you. I need 25,000 bucks out of Dad's trust. And she says, well, what do you need it for, Mom? She said, well, I think it's time I got a new car. And Presley says, Mom, that 75 Dodge Dart you're driving, so those rust holes in the door are just like air conditioning, and that muffler, I know it's really loud, but you can hear that bad boy's purring. She says, I think it's fine. I think you're good, Mom. And so Becky's obviously a little bit distraught. So what does she say to Presley? What Donald Trump used to say on TV all the time. She says, you're fired. But she still can't get the car because she needs a co-trustee to agree with her, because that's the terms we put in the trust. So that night she calls up Paxton, my son, says, hey, Pax, had a tough day today. He says, what's wrong? He says, I had to fire Presley as my co-trustee. So what for, Mom? And she says, well, I think it's time I got a new car. And Paxton says, Mom, I think you deserve a Cadillac. So what does she say to Paxton? You're hired. So she hires him and she gets her car, right? So we're going to kind of reset here after each one of these examples. So Becky can still get her car, but we've got to get have the right structure there. And you'll see why that structure is important here in just a second. So, so a couple more months go by. Becky decides it's a good day to have a stroke. She ends up in rehab at the nursing home, and they say, you're going to be here for the rest of your life. So, and before we can get Medicaid to pay anything, you got to give us all your money. And we understand you got a bunch of money in this trust that this revocable trust that's yours, and we want all that, and they can get it. And we understand that you're also a beneficiary of this other trust. We'd like that money too. And Becky says, yeah, well, my husband, before he died, you put all these cockamamie rules in this trust, and it says I can't get that money out unless my co-trustee says I can. But my daughter's a good kid. I'm sure she'll give it to you. So they call up Presley and they say, well, we'd like to get this money out of your trust for your mom's care. And she says, what if I don't give it to you? She said, well, then Medicaid will pay the bill. And she says, yeah, I don't think you should have it. And so what does Becky say to the nursing home people? Gosh darn kids these days, we can't get the money. So we've got it protected there. So we've got that now protected for Becky and the kids still, because it's not available to her. So we rewind a little bit more, and we're going to go back to our buddy Biff. So Biff comes over, and he's hanging out, cleaning out the pool. So Becky calls up Presley one day and says, hey, Presley, I need 10 grand. And she says, well, what for? Out of Dad's trust. He says, what for? He says, well, Biff the pool boy, I told you how much I like seeing him in his Speedo. Well, Biff told me if I take him to the Bahamas, he'll wear a Speedo wherever we go. And I think I really want to do that. So I'd like 10,000 bucks out of the trust. And Presley says, yeah, I don't think that's such a good idea, Mom. You've got money over here to spend for things you want to do that are fun. This money's for you if you need it, and for us kids when you're gone. So I'm not going to give you the money. So what does Becky say to Presley? She says, you're fired. And Presley says, not so soon. Those cockamamie rules that Dad put in the trust? It says in the trust, if you get remarried, then you can no longer fire me as trustee. And so Becky says to Presley, she says, hey, I was married to your old man for a lot of years. She says, I'm not going to make that mistake again. I'm not marrying him. You're fired. Either you give me the money or you're fired. And she says, if you really look at those rules even closer, it says that in the definition of remarriage, it says if you cohabitate amorously with somebody for more than one night, we're going to consider that remarriage. You can't fire them out. So that money's never going to Biff. And you can vary that definition of remarriage to make it as loose and tight as you want, but you'd be surprised how many people use that one-day rule, so that we protect that money so that somebody isn't fooling with the trust and the money there. So we lock that money in there. So we rewind again. Becky's driving home one night, and on a rainy night, she hits a guy on a bicycle, kills him. There's a $10 million wrongful death suit. They can get all the money here in the revocable trust, but they can't touch the money in the mom and kids trust over here. So it's protected. So you can see how we can build in those kind of protections inside the rule book by doing some thoughtful planning. So let's say that Becky passes away, and now we take the money from both trusts, we combine them together, and we split them for the two kids. And we make each kid each other's co-trustee, because down the line, they are contingent beneficiaries of each other, and they have that requisite adverse interest to make each of their trust asset protection trusts. And Presley calls up Paxton one day, who's her co-trustee, and she says, "Hey, Pax, I need 150 grand out of Dad's trust." He says, "Yeah, what for?" And she says, "I want to move, we want to buy a condo in Florida, so I was thinking I'd get $150,000 out and I'd go down there and buy a condo." And Paxton says, "Yeah, I don't think that's a good idea, but before you fire me, let's talk about this. Let's have the trust buy the condo. And you have the trust says in the rules of the trust that you have a right to beneficial use of any property that the trust owns. So you can live in the condo. The trust will pay the property taxes, the trust will pay the association fees, and the trust will buy it and own it." She says, "Yeah, that doesn't seem like such a bad idea. Let's do that." So we have the trust buy the condo. About 3 years later, Presley and her husband decide to move to Florida and live in the condo full time. She takes up gardening like her grandma, and her husband takes up golf. And his favorite hole is the 19th hole. So every day he's coming home from the golf course, she's out front gardening, and the guy seems happier and happier every day. So one day she finally stops and asks him, she says, "Hey, honey, what's going on? This golf thing's been great for you. You seem so happy." He goes, "Yeah, I've been meaning to talk to you about that." And she says, "Yeah, well, what about?" He says, "Well, I met my best friend at a new best friend at the golf course." And she says, "Yeah, what's his name?" He says, "It's Bambi. It's Bambi the barmaid. Real attractive young girl." He said, "One day I had enough pops, finally got up enough courage to go talk to her. Turns out we have a lot in common. We got matching tattoos, matching Harleys. Here's the divorce papers in a P.O. box. Send me half of everything." Does he get any of the condo? No, because it's locked up in that trust. So that's how we lock up money. So you can see how we can use this rule book to protect people from different situations and make sure that your money stays in the family, so to speak, because that's really where we try to start our planning from. So that's kind of how we use this thing, these trust vehicles to protect and manage your assets while all the way through the continuum. So just thought we'd share. So I'm gonna go through these last two quick, and then we're gonna wrap up. Now I'm gonna let Erica kind of finish with you. But not working with qualified professionals, and it was interesting. I was on the phone with a financial advisor today, but there's really a team, a well-rounded approach to doing this. And some people do more of it than others, but I think it's important that you ask some questions. So, and I actually was going to I'm going to try to include in the next, the next show, I was on the phone with an advisor this morning, and he said, "Here's these 10 questions you should ask your financial advisor." And they're like, "Do you act as a fiduciary?" and all these kind of things. And I think those are important, is you need to ask those questions. Like you should ask, "Hey, Jack, what kind of affiliations do you have with adds depth to your organization? Are you looking at best practices in just Lansing, Michigan? Are you looking at all of Michigan? Are you looking at it nationwide as it relates to this?" And so that's why I showed you my affiliations at the beginning, is we have national and local affiliations. One of the sayings we like to say is that, if all you did was practice in a microcosm, and if you only have a hammer in your hand, everything starts to look like a nail. So we're always out there trying to reach, search, and survey. And you should be working with financial advisors, insurance people, all those kind of people that are doing that same sort of thing. So you want to ask their affiliations, ask different questions of them, ask them if they'll ask a financial advisor, if they'll act as a fiduciary for you, those kind of things, because the expertise that you really need to build a really well-rounded plan, your attorney should know, and the guys like me should know tax law, trust law, Medicaid law, asset protection law, Veterans Administration law, and probate law. Financial advisor and an insurance person should know, and I probably should add to this a little bit, stocks and bonds, mutual funds, annuities, life insurance, asset allocation, asset management. I would add long-term care insurance, property and casualty insurance, all those kind of things, so that you make sure that we've got a shell built around your assets, so that we're minimizing the threats and protecting it to the extent that we can. So I think that's important. And then the last thing is not knowing the cost. And, again, a lot of it is you can pay me now or you can pay me later kind of thing. A lot of it is monetary versus personal, because sometimes you spend a little bit of money to know. To me, the real value in a lot of this is creating that instruction manual so that we keep the family peace. And, we make sure that people with vulnerabilities are are addressed appropriately and not taken advantage of, all those kind of sorts of things, so that, you know, when we sit down and have a meeting with you, we want to understand what the hard costs are today, but what some of the soft costs are might be down the road, so that you can make the best, you know, you have good education about how you do all this, what you should do, what you shouldn't do, what you want to do, what you don't want to do, and what it's going to cost. So I think that, and that pretty much sums it up. I'm a little bit over time as usual. But also the other thing too is to have a team approach. You know, oftentimes I'm working with advisors and insurance guys all on the same call, and it's actually become, now that we're using Zoom, it's a little bit easier to do that, to get everybody in the room together and have these kind of conversations. And then the other thing we talked about a little bit earlier is to make sure that you're staying current as your life changes, as the law changes, as your asset mix changes, that you look at all the family makeup changes, if kids are born, people pass away, all those kind of things, to make sure that you're holding this thing together. Statistics show that about 1 in every 5 estate plans ends up doing what it was supposed to do when it was created, because people don't, they fund it well when it first happens, when they first create it, and they don't manage it well as life changes. So, and you want to know how much this is going to cost. As I said, we've got a fee schedule, depending if you're a single person with a base will plan, it could be as little as $700 or $800. If you're somebody that owns multiple businesses, you know, the price can get pretty out of, you know, can get, I shouldn't say out of control, can get pretty high, but it's all relative to what you're trying to get done, I guess. But we have, when you come to your vision meeting, at the end of that, we'll put a fee schedule in front of you, and you'll see exactly what it costs and what goals would be met by picking or not met by the plan that you pick. So I think we've covered all these. And kind of at length. I apologize for some of the fits and starts. We're trying to figure this out as we go, but I appreciate your time today and commend you for coming in and just listening about estate planning, because a lot of people just, it's just one of the things that is the most procrastinated things that I know of. So, and I know I was just as guilty as a lot of other people. And then here's some of these things that, well, this is what most people want to know. This was in the other slides, but these are the things that we wanted to try to talk to you about today. Was, can you protect your stuff from the government, long-term care costs, family, and how? And yes, you can. What's a trust? What's the difference between a revocable and irrevocable? And we talked about that a little bit. How can you avoid probate, and do you need to? Can or should you give your stuff away to the kids or others? And if you do, will it take 60 months for it to be safe? And that relates to the Medicaid question. We talked about powers of attorney, living wills, or the personal care plan. Patient advocate designation, what's the difference, which do you need? Just to go back to that, I think everybody should do them. It's cheap to do, and allows you to stay in control of what's going on. So, and hopefully would reduce a lot of uncertainty in other people's lives too, when those things happen. How do you plan for disabled beneficiaries? We talked a little bit about that. That becomes more of a specific conversation at the vision meeting. Are your qualified retirement benefits safe, and do you need special planning for them? There's a couple different things there. One is that I told you, a trust can't own an IRA or a 401k or a 403b. So we do have to plan a little bit. You have to do some special planning for them. And estate taxes, for all intents and purposes, unless you're an ultra high net worth individual, have become a thing of the past. So those are some of the basic questions we try to get answered through this presentation. And so how do you avoid these threats? You plan when you can. So, and then you got to figure out what plan you need. And there's only one way. Well, I guess there's more than one way to discover it. The way you can discover it with us is to come to a vision meeting. So typically what we do there, we're going to spend 60 to 90 minutes. We're going to ask you to fill out that 4-page form and get it back to us ahead of time. We'll help you identify what's important, eliminate what's not, and provide 3 options for you to consider. So, and only at the end of that meeting do you ever have to make a decision whether you want to continue with us or not, or say, I appreciate the education, and it was nice knowing you. So, so I'll do that. I'm going to turn it over to